More about this, we're joined by legal expert Mpumelelo Zikalala. Good evening, Mpumelelo. Thank you very much for joining us on the program. So we have yet another commission of inquiry coming. As you've heard in that clip, Dr. Mamphela Ramphela is among those who are saying it would be a futile exercise. Perhaps let's put it into context for some. What is the benefit, or better put, what is the intention of an inquiry so that we almost manage the expectations?
Well, good evening to you and also to your viewers. Well, the inquiry basically says we are going to conduct a high-level investigation, which is going to be done in the eyes of the public, done by a retired judge or any person who has been appointed as that particular chairperson, with clear terms of reference as to what is supposed to happen. It is not an adversarial type of process where one is being accused and they would need to defend themselves. And an invitation would usually be sent to all individuals to say, come to us if you have any information so that you could be able to assist us. But if you look at the second line, when you look at the preamble of our Constitution, it says that recognizing the injustices of our past. Now, you cannot give effect to that particular phrase if you're not going to ask the question of saying, how did our fallen heroes die? Was there other ulterior motive rather than a political one? Is there anyone that you can be able to hold accountable in all these processes, and how do you go about doing that? There's no other way in which that can be done by either than holding a commission of inquiry within this developed democratic state that we are in now to say, come forward so that you can be able to deal with all the misfacts, with all the truths that are there, and be able to prosecute those that can still be able to prosecute.
Mm-hmm. Now, the cost of commissions of inquiry are also a big concern for citizens, even some who are for some sort of a fact-finding mission or inquisitorial mission such as this one. For them, what discourages them becomes the cost of supporting such a decision. Would there be any way where costs could be limited when it comes to commissions of inquiry?
Yes, there could be a way if you are going to look at the manner in which those particular inquiries are going to be done. The very easiest one, or maybe the most practical one, is to say, show us something which is written in writing first, then you'll be able to determine and assess whether your information needs to be investigated further in live or what we would call viva voce evidence. In that process, you are able to eliminate things which are not important and be able to focus the commission towards the direction in which is going to get to the meat of what you are actually looking for and nothing else. So there are innovative ways of being able to do that. The other one is using technology. You don't have to fly everyone to Cape Town or Pretoria or Johannesburg. Virtual sittings can also be held so that you're able to minimize the cost of people traveling and paying for hotel cost or accommodation cost. So there are a number of ways in which the commission can be able to sit and look at and say, how can we be able to make sure that we're able to contain the cost, but doing the most important job of being able to extract the truth.
I was hoping you'd also add that legal practitioners would actually come pro bono, because for all the voluminous documents that they have to read, they are billing. They send an invoice for that. So what happens in that respect?
Definitely, but it would also depend as to whether those legal practitioners are in position to provide those pro bono services. However, if that can be shared in intent to say, well, maybe don't charge us your full rate, give us a rate which is reasonable, or limit the rates to what the magistrate court or the high court would actually prescribe. Those other processes or other innovative ways in which you can come to and then say, how can we share the voluminous work that is there to be able that it is scrutinized by legal practitioners, and legal practitioners are part and parcel, so that the person who's going to do the assessment will still be do it in a much easier sense. Remember that the chairperson of the commission simply does part one. There's part two, which is the prosecution, part three, which is actually making sure that those that are found to have transgressed, at the end of the day, they are found behind bars. So to me, that's the most important part in the whole commission's life.
And then before I let you go, Mpumelelo, we have the LPC. It began its disciplinary inquiry against Advocate Dali Mpofu today, although not much was done due to the power issues and that amendment of the charge sheet. But just your reaction to, firstly, the amendment of that charge sheet, where Advocate Thulima Donsela and Chief Justice Mandisa Maya, the individuals who were reportedly at the receiving end of the unbecoming conduct by Advocate Mpofu, they've expressed that they have no desire to partake in the disciplinary process, hence the amendment of that charge sheet. What did you just make of that?
Well, the charge sheet can be amended at any time. It's not something which is untoward. However, it is a bit concerning, though, to say you're not going to trudge and forge ahead with any charges against, especially legal practitioner, not any legal practitioner, senior counsel at that, not having consulted with the individuals or the complainants at hand. So you ought to have investigated and made sure that your charge sheet is tidied up before you even laid those charges before the Advocate Dalimpofu SC. And to come back at this late stage to want to amend them, if in those allowed within the rules, it does cast a bit of the aspersions to say, are these really charges that should be listened to by the LPC, or are they charges which are peddled by other individuals with no merits? But what the process or the forum that should be able to determine it is actually the tribunal itself.
But when listening to Lawson Naidu from KSEC, those that brought actually these charges, they're saying that an inquiry is not determined or does not stop purely because of no participation on the part of those who are actually supposed victims in the whole situation, that it can still continue.
Even though it can, but you must then go back to the rules of evidence. It's the quality and the quantity of the evidence that should be there. So if there's no one who's going to lead the evidence that is there, provide context in which those questions were being asked, then it means the task of being able to prove that the person is guilty is going to be a very difficult one. Remember, there must be a complainant, and that complainant must be able to substantiate those complaints by providing evidence. So if the person who was being cross-examined, for example, is not going to come and say, I felt offended, I felt as if it was overstepping of the mark, I had answered the question in this particular manner, then it's going to be very difficult for the person who's prosecuting to be able to prove that whoever is being prosecuted is indeed guilty of the misconduct.
So Advocate Dalimpofu's confidence is not misguided in this respect. Possibly he might win or at least come off scot-free in this particular inquiry, given that at least the two women have stated that they don't want to partake.
You could say partly so, but remember there are other charges that are there that carry as much weight in terms of the sentences or the sanctions if he's indeed found guilty. But it does bolster his case to say, I had 7 or 8 charges that were laid against me. I've now been able to reduce those charges to at least half, so I can at least focus on those 4 charges that have been laid against me, so that I can be able to look and see if I can poke holes in whatever has been stated there. But the most important part would be in the manner in which the work of a legal practitioner is done, and in line with the Legal Practice Act and the Code of Conduct, are there any transgressions that have taken place? And also take into account that if you look at a tribunal or a court or a dispute resolution forum, it is a contested terrain. There are going to be views which are going to be expressed. There are going to be emotions which are going to rise. But at the end of the day, it's all cordial within the context of that contested terrain.
And then just in closing, when that first announcement came, or the news came out that there would be a disciplinary inquiry by the LPC, I remember the statement by Advocate Thuli Madonsela, quite scathing. She went on to state that beyond not being interested in partaking in this particular inquiry, she also felt as though her agency was taken or stripped away from her because she didn't get to take the decision to either lay a complaint or not. She just found out that she's party to some sort of an inquiry. What did you make of just that? Insofar as the credibility of the process in that respect, that she found out like everybody else that a matter relating to her, who is supposed to be at the receiving end of some sort of unbecoming conduct, is a person who finds out like the rest of us and says, you stripped me of my agency to decide.
Well, it comes back to the motive or the intention of the complaint being made. Do you then come back and say, what's the real motive of it? Is it out of the protection of the integrity of the noble profession, or is it something else that ought to be considered? Also, on a professional basis, if you're going to use the name and the content and the participation of someone in any tribunal or any sitting that has taken place, it is only courtesy, even not even courtesy, it's mandatory that you must go to them and say, this is what I'm going to do on your behalf. I felt that the manner in which you were treated is not a manner which is supposed to, you were supposed to be treated in, and on that basis, I'm going to lay your complaint. What is your view? At least that participation, that part of consent ought to have been received from Advocate Thuli Madonsela, not to just simply let things go through and simply say, I'm going to file a complaint on your behalf, and I'm not going to go to you and seek that consent so that I can be able to move on with other things. So it does cast a bit of the aspersions, and I think that it's going to be one of the points which is going to be lamented on when the tribunal actually starts to come back and say, what is the real motive of the complaint and what is it that seeks to be achieved by the complaint?
And then those two matters aside, though, there are still those who feel that legal practitioners or even judicial officers, their conduct has to be beyond, they have to be people who are beyond reproach in most instances. And there have been times where the exchanges to the ordinary person who wouldn't really have that much of a legal appreciation would feel that it's not so collegial, that in most instances when you're going to hear a legal practitioner say you're going to pay for this one day, it's not a threat, it's a promise. Or we've even heard at one point the late Minister of Public Enterprises, Pravin Gordhan, I think it was him that was told to shut up, or one or the other. So there have been those instances. I mean, in that respect, is this conduct that in a very heated exchange is something that is normal in the legal practice, or it is to a certain extent regrettable?
Well, we must view it within the context of saying, one, we are in the contested terrain. So there are going to be views and things which are going to be there. Secondly, legal practitioners act on the basis of instructions. So if my instructions are to say to a person that I'm cross-examining their line, that's exactly what I'm going to state. It may differ in a manner in which I'm going to ask them or maybe put it to them that they're indeed lying, and try and provide those elements in which I would expose that they're not telling the truth. But at the end of the day, it is going to be contested and the emotions are going to run high. There may be one or two instances in which emotions would go overratedly high. That would be regrettable in a manner. However, it's taken within the context of everything else which is taking place, and I think that's what the tribunal would seek to do. But in doing that, the one thing in which I do not think they wouldn't want to go into is determining and creating barriers when it comes to legal practitioners and with them conducting their work, especially during cross-examination. Legal practitioners cannot conduct cross-examination under the fear that one day complaints are going to be laid against them. It should be a free space, a space in which you're able to extract the truth. If emotions do run high and there are certain instances of misconduct that have taken place, the Legal Practice Act is there, the Code of Conduct is there, and that is going to be the master in which you can then be able to test whether those particular conduct were done in a correct manner or not.
All right. Mpumelelo, thank you very much as always for your insights. That's legal expert Mpumelelo Zikalala.